All rise. The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good morning again. We are glad to be here for the second argument here in historic Randolph County. This has been an amazing time, and we're just so grateful for everybody who has been so gracious in helping to make this happen, to host the Supreme Court of North Carolina in this 200th anniversary year for the court. I am Sherry Beasley, the Chief Justice of the Supreme Court of North Carolina. To my right is Senior Associate Justice Paul Newby. To my left is Justice Robin Hudson. To Justice Newby's right is Justice Sam J. Irvin IV. To Justice Hudson's left is Justice Michael Morgan. To Justice Irvin's right is Justice Anita Earls. Justice Mark Davis is not with us today. He is observing Rosh Hashanah, but he is also recused on the matters before the court today, and so he will not be participating in this court's decisions on these two cases. The court calls City of Charlotte versus Universal Financial. Mr. Meeker.
Chief Justice Beasley, member of the court, and may it please the court. My name is Charles Meeker. I'm with the law firm of Parker Poe, Adams & Bernstein in Raleigh. I'm with my colleague Steve Carey, and we are representing the City of Charlotte in this appeal. First, let me thank the court for taking this case on discretionary review. I know your docket is busy, and we very much appreciate it, having been the losing party below, that you're taking a further look at this case. The first issue is when a motion to amend the city's pleadings to reduce the amount of just compensation is pending, does the trial court have the power to decide whether the landowner's notice of dismissal is effective? That's the first question. The facts in this case start with the filing of the complaint in April of 2013. The amount of just compensation and the deposit was estimated at $570,000, and it included both the land taken as well as off-site impacts for a nearby bridge. When this came to be discussed at mediation in the fall of 2014, the city then filed motions to determine issues other than damages, and also a motion for partial summary judgment to have the court rule that the off-site impacts were not compensable in this in condemnation action. While the trial court did not agree, the Court of Appeals would then Judge Davis, now Justice Davis, ruled for two reasons that the off-site impacts were not compensable. So when the matter came back to the trial court after discretionary review was denied, the city moved to amend its estimate of just compensation from $570,000 to $174,000 to take out the effect of those off-site impacts. The city did not move to change the deposit. So the question here is, okay, we now have this notice of dismissal. Let me put that in. The University Properties filed a notice of dismissal a week after the motion to amend was filed. So then the trial court's faced with this motion to amend to reduce the amount of just compensation requested by the city, and then also this dismissal by the landowner. Well, the Chapter 136 eminent domain statute and the rules of civil procedure do not have any process for a defendant dismissing an action. There is a process, of course, for an amendment of the pleadings in Rule 15 and also under Section 103D of the condemnation statute, which allows amendments at any time.
What's your response to the majority's position in the Court of Appeals, as well as your opponent's position that because of this unique statutory construction that undergirds eminent domain, that as a result a defendant in a condemnation action is really like a plaintiff in terms of being the one that would initiate the dispute, because otherwise there would be no dispute, as a plaintiff typically is the initiator of a controversy such as the one here that would involve damages?
Well, there are some similarities to a defendant's position in a condemnation action to a plaintiff's position in a normal civil action, but there's one really, really big difference that applies here. And that is under Rule 41, when a plaintiff takes a dismissal, the plaintiff walks out of the court with nothing other than the right to file again within a year. In this case, if the dismissal by the defendant is effective, then the defendant will walk out of the court with $500, or will keep a deposit of $570,000, of which $396,000 is in dispute as being an excessive amount, and thus obtain a windfall of $396,000, being allowed to file that dismissal if it's effective. And that's the reason that the statute 114, section 114 of chapter 136, gives the trial court the power to make decisions on issues of procedure when there is nothing in the rules of civil procedure and there's nothing in the condemnation statute either.
Who makes that determination that it's a windfall?
Well, that of course is the city's contention. The initial deposit included these off-site impacts, which the Court of Appeals found were not compensable, and this court didn't take the case. So now the city has re-estimated the amount of just compensation just for the land taken, not for the off-site impacts. And the city has estimated that at $174,000.
So the windfall is occasioned by the fact that the bridge is not determined now to be one that would impair the site opportunities, and so therefore, since it does not impair the landscape for view, that's why there's a diminution in the value?
Yes, well, the amount of compensation, I think the court decided that even though there was some visibility affected, that visibility was not something that was compensable in this case.
And that's what would make it a windfall,
right.
Because it's not compensable.
Right, it's not compensable, and thus the city's estimate is $174,000 instead of one that included the off-site impacts. Now, of course...
Why doesn't that just fall on the responsibility of the condemning authority? Certainly in the course of discovery and leading up to trial, the condemning authority could say, oh, we misvalued any particular aspect, and wow, we deposited this, but maybe we shouldn't have. Why isn't it the responsibility of the condemning authority to make not just judgments as to the value, but also what is involved in the taking, and have to live with whatever determination it makes?
Well, the statute does not require that there be no change. Indeed, Section 103D allows amendments, and that's exactly what this kind of thing is for, in case there's been a misestimation of the just compensation, there's not the right party, maybe the property's not described right. 103D allows amendments, and that's what it is for. Certainly it'd be more desirable for the initial amount of just compensation to be estimated correctly. However, errors do occur, and that's what happened here. And of course, it was brought to the attention of the other side in the court very quickly.
Well, 103D says that there can be an increase in the amount of deposit. I don't see anything about a decrease.
Okay, well, let me address that, because the Court of Appeals was confused on that. The city has made no request to change the deposit. What the city has requested is to change the estimate of just compensation. So when the amount of just compensation is ultimately determined, then if the deposit is in excess of that, some would be refunded. If the compensation is more than that, then of course the city would owe more. But there's been no request here by the city to change the deposit. And we think the Court of Appeals, in looking at that statute, was off the mark, because what we're talking about here is the estimate of just compensation. The deposit is something that's held during the course of the proceeding by the landowner. Just compensation is the ultimate amount determined owed by the condemning authority.
Let's say that you had, let's say you know, $570,000 on deposit. At the end of the trial, though, the court determines, the jury, someone determines that, hey, what amount is due is $200,000. Does the person whose land's been condemned, do they have the right to go and, okay, now we want that full amount? Or
no.
Are they stuck with whatever the court determines?
Under Section 121 of Chapter 36, there's an express provision that provides if the amount of just compensation is determined to be less than the amount of the deposit, then that amount must be refunded. You cannot go back at that point. Once you dispute the amount of just compensation, you put that issue in play. And if you don't dispute it, you can keep the deposit and go home that day, and the case is over. But once you give your answer and dispute the amount of just compensation, that issue is in play. And although often the value is more than what the deposit is, in the cases where it's less, Section 121 makes very clear that that excess amount must be paid back.
So in that case, it sounds as if the the outcome on the issue of the Rule 51 voluntary dismissal is pretty important as to whether you
yes,
get to
right.
continue to dispute that.
Whether it's effective, that's correct. And our contention is that the trial court under the Section 114 is given the power by the General Assembly to make procedural rulings where there is no procedure set out either in Chapter 136 or the North Carolina Rules of Civil Procedure. And here the trial court did that. It looked at it and said, we've got these competing motions. The the first estimate of just compensation appears to be excessive. It included these off-site impacts, and thus I'm going to allow the motion to amend. I'm not going to allow a windfall to the defendant. Indeed, the purpose of Chapter 136 is to achieve just compensation. It's not to have some procedural impact, that gets to the wrong result. The trial judge is directed by Section 114 to try to achieve the purposes of Chapter 136, which is just compensation.
What is it about Rule 41A that doesn't, or A1, that's inadequate to address the situation where it says that the action or any claim therein may be dismissed by the plaintiff without order of court?
Right. Well, the plaintiff here is the city of Charlotte, and the defendant is the landowner. So Rule 40.
Even though, as Justice Morgan asked, it's treated more like the plaintiff.
There are similarities there, but again, this Rule 41, applies to plaintiffs. There's no reference to defendants and defendants dismissing a plaintiff's claim. And the difference here is, of course, I think I mentioned that Rule 41, when a plaintiff dismisses, the plaintiff doesn't get anything. And here, if a defendant is allowed to dismiss, if it's somehow given Rule 41 rights, it walks out of the court with a windfall.
So you're asking us to hold that Rule 41 does not apply to the landowner in a condemnation proceeding?
Yes.
Just flat out?
Yes, we are.
What if there's been no motion to amend at all? Are you saying a defendant in these circumstances can never voluntarily dismiss?
Well, there are two things a defendant can do. One is, of course, when you answer the condemning authority's complaint, you can admit the amount of just compensation is right, and that ends the action. Or you can not answer, that also ends the action. If, after you've answered, disputing that issue, you now want to end the case, you would then move the court to dismiss the case, saying that you now think the amount of just compensation is correct. And the condemning authority presumably wouldn't object unless there's an unusual situation like this case. That's another point I want to make. This case is very unusual. I don't recall another one where a condemning authority has found out that its initial estimate was this far off. So this is not as though this is going to affect a lot of cases as far as I know. But I think the answer is there is no right of the defendant in an eminent domain case to dismiss. So you have to go under Section 114, where the trial court would then, presumably would accept the motion in that case. There's no dispute at this point about the amount of just compensation.
But isn't that essentially what happened in the Coombs case? I mean, whether you characterize the defendant showed up at court and didn't put on evidence, or the defendant voluntarily dismissed, the ultimate outcome of that case was that the defendant dismissed their attempt to get more compensation and kept the deposit.
Well, there's a lot more to the Combs case. It was been called for trial. The landowner's attorney was saying that they didn't want to challenge the amount. Apparently the individual defendant did want to challenge the amount. There was no request to continue. And then ultimately the court said, well, that appeared as though the defendant had abandoned the claim for more compensation. There, the situation was exactly the opposite here. That is, the landowner was trying to say, well, I didn't really dismiss or abandon my claim. I'm entitled to more compensation than what the state said. And here, of course, it's just the opposite. So I think the Combs case, one, is really rather different when you look at all the facts of it. And then secondly, of course, it's not authority that binds this court. I think this court needs to rule what the right answer is here in terms of whether Rule 41 applies to defendants, which we think it doesn't, and whether the trial court has the power under Section 114 to make procedural rulings. And on that, we think the Court of Appeals just used the wrong standard of review. That is, it went ahead and reviewed it, so it did its own review as to what it thought was fair, and also misunderstood that a motion to reduce the deposit was not an issue. It was a motion to amend the amount of just compensation. And here, certainly, the trial court's ruling, was a reasoned decision. It wasn't, a manifest abuse of discretion. It avoided a windfall. It appeared to follow what the Court of Appeals said, that is, the landowner should not get this off-site impact. And also, it carried out the purpose of Chapter 136, which is arriving at just compensation, which is the policy of the state. I mean, the landowner is entitled to just compensation. The landowner is not entitled to some windfall where it gets 2 or 3 times the amount of what just compensation is. So in that first issue, we believe that the trial...
So just to finish up though, Mr. Vicker, your position then in essence is that a defendant in a condemnation action cannot voluntarily dismiss its claim and therefore put itself in the position that existed in the Combs case unless it is willing to accept the amount that the condemnor contends to be the amount of just compensation at the time of the dismissal. Is that your position?
That would be correct. That is the time they answered the amended complaint, which the judge allowed. They could then say, yes, we agree with that amount of compensation, $174,000, and that would end the case.
So in the event that the motion had been allowed, the motion to amend had been allowed, in your view, the defendant could take a dismissal at that point
They
and
could
accept, in this instance, the $170,000?
Yes, they could accept 174 under the statute on the answer.
I mean, I think your colleague's argument is that puts us at, I mean, that the whole purpose of this is to create some certainty into the process, and that this allows entities that are condemning property to create a moving target, and that's fundamentally inequitable. I mean, what's your response to, I think that's one of their arguments, I don't think it's the only one, but what's your response to that?
Well, if a motion to reduce just compensation is made for an improper purpose, that is, there's not something valid like here.
Well, let's not just assume it's an improper purpose, let's just assume there's a series of errors.
Well, I mean, the trial court would decide whether to allow that motion to amend. It's in the trial court's power to decide whether to allow that happen, whether that furthers justice and whether that's a fair result.
So if the trial court had denied your amendment motion in this case, you don't dispute that the landowner at that point would have had the right to file a voluntary dismissal and take $500,000 and some odd that were part of the initial deposit?
Well, I'm not sure they would be filing a motion to dismissal, but if the trial court had denied the city's motion to amend, presumably then the court would then grant a motion to terminate the case.
Or voluntarily dismiss, not
Right.
a motion to dismiss. Sorry about that.
Yeah.
So your position is that there needs to be a stipulation of dismissal at this point?
Well, a stipulation of dismissal or the court's approval, because there is no provision for a defendant just to dismiss in any, under Chapter 136 or in the Rules of Civil Procedure.
How does your view of Chapter 136 and the usage of Rule 41A fit this construct of a condemnation action, which is that when the plaintiff, such as your client, decides that it wants to condemn land for a public purpose, that the title automatically goes to that municipality or that governmental entity?
I think that part is really sort of separate from the amount of just compensation, as the title is vested at the time the suit is filed. So that part of the case is over, and what's left to decide is the amount of just compensation. And if the landowner agrees with the estimate of the condemning authority, the case is over. If they don't agree, if they dispute that and put it in play through their answer, then that's yet to be determined by the court, and that's where the court's power.
What I'm looking at relative to Rule 41A's usage is if you say that it's only available to a plaintiff such as, again, your client, as soon as title vests, then there would be no need to voluntarily dismiss by the plaintiff because the plaintiff's already gotten what it wants, which is the land and title to it. So really 41A is not available to any party, I hear you claiming, in a condemnation action.
Right. Well, once you have taken the title, of course, then the condemning authority cannot undo it by returning the property at that point. So I agree, 41A does not apply to either party in a condemnation action. That's correct.
So that's why Chapter 136 governs all of this?
It governs this, and that's why it gives the authority to the trial court to make reasonable rulings to carry out the purposes of Chapter 136. And again, that's Section 114 of Chapter 136. The second issue, and we've covered this pretty much already, is whether the property owner can keep an incorrectly large deposit when the motion is pending. And of course, we say that it should not. And I think part of this deals with the McCarley case, where there's a request for an affirmative relief pending by one of the parties that's in the case. And here the city's motion to amend was in effect a request for affirmative relief, the just compensation to be determined $174,000 and not be determined to be $570,000. So for that second reason, we feel that the trial judge was correct in allowing the motion and not letting the dismissal be effective, and the Court of Appeals was not correct. Just briefly on a couple of rebuttal points, the defendant's brief refers to the vested deposit. I am not aware of any vesting of deposit. There is the vested right to just compensation, but the deposit itself is not vested. Indeed, under Section 121, part of it can be returned if just compensation is found to be less. We talked about the Court of Appeals' confusion on the issue of what the motion to amend was. It was a motion to amend the just compensation amount, not to change the deposit during the trial.
I think your colleague argues that that's a distinction without a difference. I mean, in essence, if I'm reading the brief correctly, and you'll have the chance to correct me if I'm misreading it, she seems to be saying that you can't really separate the two, that if you amend the estimate of just compensation, you've effectively amended the deposit amount as well, even though you haven't, and I gather her theory is we had an absolute, at the time that the original estimate was 500 and some odd thousand, we had a right to go get that, and that by amending your position, you are essentially moving from a position in which you contest our right to have that entire amount to contesting, you don't contest the amount, the ability to keep all of that amount, but to a position in which you are contesting her ability, in this case, to keep over half of it.
Right. Well,
and she thinks, in her view, that's essentially the same thing.
Well, I respectfully disagree with that argument. The deposit and the amount of just compensation are two different things. The deposit is an interim step that the landowner is entitled to hold the money pending a determination of just compensation. So it's something that occurs prior to settlement or prior to trial, and it's not something that the landowner is entitled to. It's something they hold pending the final determination. Just compensation, on the other hand, is that final determination. So here, when the motion to amend was granted, it didn't affect the deposit. The landowner is entitled to keep that full deposit until just compensation is determined, and then it would have to either get paid more or refund some, depending on what that amount is. But there was a big difference in the function of a deposit pending a determination of just compensation versus the concept of what just compensation is. So I respectfully don't agree they're the same. Okay, and the final point was on the question about multiple motions to amend. Of course, if someone did that, the trial court would consider each, and presumably if they weren't, if they were for an improper purpose or harassment, or there were too many of them, the trial court would deny them. So that's something the trial court is close to the action and can make fair rulings.
Tell me the impact of the amendment, because it would seem to me that even without the amendment, the condemning authority could put on evidence that we made a deposit, but in actuality, the value is much less than what we deposited. And ultimately, if the court rules in favor of the condemning authority, it doesn't matter what the valuation that would have been set out in the complaint. Is that accurate?
Yes, you're exactly right. This is something the city didn't have to do, but it put the landowner a formal notice that we're going to seek a lower amount than what was initially estimated. But as you say, at trial, even if there had been a higher estimate, the condemning authority could have requested a lower amount. So this is really an additional notice to the landowner.
So at what point could the landowner have said, we'll take the initial deposit, that's enough, and we don't need to contest this anymore?
Okay, when it filed its answer under Section 107.
So even the next day, they would have needed the consent of the city of Charlotte to have stopped the proceeding.
I'm sorry, I didn't get your question.
Even the next day. So
next day
they file
after
their request for this valuation, and then they decide, oops, we'd rather just take the deposit.
That is the initial complaint in 2013. Yes, they could have filed an answer the next day and have taken that deposit and gone home.
No, but once they say, we want this to go on for hearing, is there a point then that they can go back and say, we've evaluated, now we change our mind?
No, the Section 107 procedure is passed once they file their answer and dispute the amount of just compensation. At that point, they've got to go to the trial judge if they want to get the case dismissed.
Well, I think at least under Combs, it would tend to suggest that if you were in the position that you answers to Justice Newby described, 3 weeks down the road, 6 months down the road, there was no motion to amend, the defendant could abandon the case. There'd never been a determination of just compensation, and therefore take the entire deposit. Are you saying that Combs was wrongly decided?
Well, I'm not sure that's what Combs really decided. It was a case called for trial. The trial court was saying that the plaintiff accepted, or excuse me, the landowner accepted the amount, and that the landowner then later contested what his attorney had said. I think there was a lot more at play there than here.
But I guess what I'm trying to figure out is your argument that it's the filing of the answer that then precludes the taking of a dismissal, or is it the filing of an amendment motion suggesting a lower estimate of just compensation?
Well, there is no right to take a dismissal. The answer gives you the right to take the deposit and go home. And then particularly once a motion to amend is pending, that's in effect an affirmative request by the city to have a lower amount. Certainly then, there's no right to dismiss, and you have to go to the trial court, have the trial court rule whether the motion to amend should be allowed or whether the effort to abandon the case should be allowed. Okay, with that, we would request that the court...
May I ask just one question? Sure. This is not in the briefs, but I'm curious about the Court of Appeals jurisdiction here. Why isn't this an interlocutory order, and that no substantial right is at stake? Should there have been an appeal at this stage at all?
Well, there was a good deal of briefing of that point at the Court of Appeals, and you'll see the first half of the opinion discusses that, and actually the city was taking that position. Once the Court of Appeals ruled and we got here, it seemed like let's go ahead and get a ruling since we're this far along. The trial court did find under Rule 54B that there was no reason not to have an immediate appeal, and the Court of Appeals rules on that point, and we did not contest that into petitioning for discretionary review. But certainly that's the position the city took at the Court of Appeals.
Thank you.
Okay, we request that the Court of Appeals be reversed and that the trial court be affirmed in allowing the motion to amend, not giving effect to dismissal, and then setting this matter for trial for unjust compensation, because the landowner doesn't have to accept the 174. They can request another amount for the property actually taken, but they can't request amounts for the property or the offsite impacts that is ruled is not compensable. Thank you.
And Mr. Meeker, I don't think you requested rebuttal time, but you certainly have some time available if you wish to use it. Ms. Todd.
Good morning. Chief Justice Bleasley, and may it please the court. My name is Suzanne Todd, and together with David Brennan, we represent the Applee University Financial Properties in this matter. University Financial did not want to sell its property to the City of Charlotte, so the City of Charlotte took it. In this case, the City of Charlotte took title to University Financial's property the instant it filed this condemnation action and made that deposit. When the city took ownership of the property owner took ownership of the deposit.
Well, I hate to interrupt you this quickly, but isn't Mr. Meeker correct in saying that 136-104 says that what vests is your right to just compensation, not your right to the deposit?
Well, Your Honor, I would say that the property owner has the right to that deposit. The property owner has the right to immediately withdraw that money per the statutes and use it for their use.
It is subject, let's say we didn't even get into the current situation. If you'd gone to trial and the amount that the property was determined to be worth was less than the amount of the deposit, the statute provided for the city to have a right to recoup the portion of the deposit over and above the estimate of just compensation. I mean, the determination of just compensation. Is that right?
That is correct. There is an opportunity if the property owner decides that it wants to have a jury decide just compensation. And in fact, that jury comes back with a lower opinion of value or a lower decision on verdict on damages, then there is a statute that would allow the condemnor to request a return of a portion of the deposit.
So you don't.
However,
go ahead.
I apologize. On the date of taking, the property owner owns that deposit, it has the right to withdraw, it has the right to use it. It can use it to keep its business afloat while construction is going on in the project. It can use it to renovate its property. It can use it for whatever purpose it deems.
But it faces some risk of being required to pay some part of it.
That's correct, but the property owner is the one with the right to trial, and if it elects to pursue and go to trial and hand off the decision of what is just compensation to a jury, yes, it's exposed to that risk. In the same way, we may have a retirement account that is vested, but if we take that money and we take it to Las Vegas and gamble with it, we run that risk. But it doesn't mean that we don't have the right to that money to begin with.
No, but, you know, it seems to me we're in a situation here, since I've already interrupted you, I was going to ask you the question anyway, and so I'm just going to go ahead and do it. It seems to me we're in a situation here where the city files its, action, makes the $570,000 deposit. You had the right to take that $570,000 deposit, not ask for a determination of just compensation, and walk away, correct?
That is correct.
Okay, but what happened here is that you filed a request for a hearing. You answered it and asked for a determination of just compensation. You then wound up litigating an issue that went all the way to this court on discretionary review as to what was compensable. Your client did not prevail in that litigation, and then at that point, you, having made an attempt to obtain a recovery of the view-related issues associated with the construction of the elevated railroad or elevated train, at that point, you try to take the $570,000 deposit that at least the city says included a component for view-related damages. And your contention is that you ought to be allowed to do that?
That is correct, Your Honor.
All right, how is that? I realize we're not sitting here as a court of trying to decide what is equitable in a broad global sense, but both of you have discussed policy-related issues in your briefs, so I think this is a fair question. How is it equitable to allow you to do that, to litigate an issue, lose it, and then come back and take an estimate, take a deposit that's based on an estimate that assumes that something was compensable when it was determined not to be?
Well, what the panel in University Financial One said is that it was dealing with a 136-108 motion, where really all issues, it was regarding the extent of the taking. As part of the holding, the court did say that if you take this case to trial, you may not present evidence of damages due to lost visibility. But again, that is the property owner's decision whether or not to take the case to trial. As far as a fairness argue or the windfall argument, I know that is just sort of a hot button word.
Well, obviously, I'm not so far removed from the practice that I don't remember how everybody tried to characterize everybody else's position in a manner that was most favorable to them. That's nothing new.
Absolutely, Your Honor. As far as if you want equity, if we talk about equities, it is the city of Charlotte who has the ability to decide what property it needs, what property it wants, and how much money it's going to deposit. If there is, in fact, the city of Charlotte obtained an appraisal, they had it reviewed, their council filed condemnation action, and it wasn't until 18 months after University Financial withdrew that money, which is allowed to by statute, that the city said, hey, we changed our mind, we think it's worth less. In the meantime, the instant it has filed its condemnation action, it takes title to our property. And in the same way that Mr. Meeker said, the city cannot reduce once it takes property. It can't undo the taking. In that very same way, once it's made that deposit, it cannot it cannot undo that. It cannot reduce that deposit amount, and the statutes are clear on that to protect. So from an equity standpoint, between the property owner who didn't ask for his property to be taken and the city, who had every opportunity to look at their appraisal and decide what they were going to deposit, the tie on that has to go to the property owner. And that's what the statutes intend to protect. And even if there's a change subsequent to the taking, new case law, a change in conditions, a change in value, between the property owner and the city of Charlotte or the government, the property owner has to win. And that's why these statutes have been enacted by the legislature in an effort to protect the property owner's rights. And that is exactly why 136-103 is very clear that you can amend your complaint and your declaration of taking and increase the deposit.
With the statutes just saturating all of this in terms of controlling how it all operates, what's your position on the other side's view that that's yet another reason why Rule 41A is not applicable here, because the nomenclature doesn't set up, you're the defendant, they're the plaintiff. 41A talks about a plaintiff taking a voluntary dismissal, and that general civil procedure rule just doesn't fit a statutory construct such as this.
Well, Your Honor, Justice Morgan, you're correct in that you're right. The condemnation cases are odd. The property owner has the burden of proof. The property owner has the right to trial. The property owner goes first at trial. In all effects, they are the one with the claim. And the condemnation statutes, though comprehensive, do not address every opportunity or every type of procedure. However, what they do address, they do give the opportunity in 136-114 for a judge, trial court, to carry into effect action or some type of conduct, a process or some type of conduct that is not contemplated within the condemnation statutes. And so that is an avenue whereby the trial court could, for instance, allow a voluntary dismissal and perceiving that the plaintiff is actually, or the defendant is actually acting like the plaintiff in the case. The property owner is the one with the claim. I would also point out that Rule 41C talks about dismissals by cross claims, counterclaims, and it so clearly envisions that it's not just the plaintiff. So just because it doesn't say the word defendant, I believe Rule 41C does envision other parties being able to dismiss as well.
So you go ahead.
Are you following it? Go ahead.
May I? Yeah, thank you. So in terms of Rule 41A not exactly fitting in terms of the fact that it somewhat feels like in a way it shoehorns in civil procedure into a statutory provision, nonetheless you feel as though the majority is correct here in terms of the fact that although the nomenclature doesn't set up the same way, that a defendant in a case such as this is a plaintiff and this court should declare it definitively as such?
Correct. It is not, by name only is the defendant property owner in a condemnation action, not the plaintiff. It is the one with the claim, and there is in the legislature, condemnation statutes allow a court to enter, allow the court to carry out function and allow the property owner to dismiss his claim.
You indicated under, as the two work together, you got Rule 41 and then you have Section 114, and that under 114, as the trial court seeks to utilize certain aspects of the rules that it, quote, could allow a voluntary dismissal.
Yes.
Does the could mean that there's discretion with regard to how the trial court looks at every different situation?
It depends on whether it is something, there is some discretion, but 136-114, it authorizes the trial court to carry into effect actions that are not otherwise, where a specific mode or manner of process is not already set forth in the statutes. So for instance, when a property owner wants to end and done with litigation, wants to get out of the condemnation case that was filed against it, that case law and combined with the statutes, the courts have recognized that the voluntary dismissal is a vehicle where they can really get relief and walk away.
Do we review what the trial court did for abuse of discretion?
Well, it's interesting because I believe the city's position is that 136-114 allowed it through, I guess, allowed it to deny the voluntary dismissal and declare it a nullity through the use of 136-114, but 136-114 authorizes the trial court to do something, to carry something into effect that's not otherwise contemplated in the statutes. What the city is saying is that 136-114, it does not allow the trial court to prohibit something that is not otherwise contemplated in the statutes.
And I guess that was one of the questions that I was going to ask you, just to follow up and make sure I understand your answer to Justice Newby. Is it your argument that the trial court was required absolutely to allow a voluntary dismissal? Or did the trial court have the right to refuse to allow it?
There wasn't a motion to dismiss. There wasn't anything. I do not think that the trial court had the authority. I think case law is clear. And it did not have the authority to even consider the voluntary dismissal.
So your argument then, at least at this point, is that that your client has an absolute unfettered right to file a voluntary dismissal and have it have the effect that you are contending for?
Yes, I believe that voluntary dismissal is an appropriate vehicle for a litigant in a claimant in a condemnation action to give up their right for additional compensation.
But I think the reason that both Justices, I know it's the reason I'm asking, and it sounds like it's the reason that Justice Newby was asking about this point, is you said a number of times that the trial court can allow the filing of a voluntary dismissal, which sounds to me to be different than the trial court has no role in and cannot prohibit you from filing a voluntary dismissal.
Once the voluntary dismissal is filed, the case is over.
So your argument, at least at this point after our colloquy here, is that you have an absolute unfettered right to file a voluntary dismissal and take the entire deposit regardless of what the trial court thought was appropriate.
That's correct.
And just to, oh, sorry, please.
I was just going to try coming at it from a slightly different way. If we hold that Rule 41 does apply in these condemnation cases, then your argument would be that you had the right to file a notice, end of story, and end of case.
We would have the right to file, a property owner should have the right to file voluntary dismissal any time prior to resting its case at trial.
And would
once it hands off to the jury to make a decision on just compensation, it's over.
And that's if we hold that the Rule 41 applies to these cases. If we do not hold that it applies strictly and that it's Section 114 that governs the procedures for this kind of situation, since if it's not specifically addressed in Rule 41 and all of the arguments that the other side has made, then you would agree that Section 114 appears to put it in the discretion of the trial court about how to fashion that procedure.
That is correct.
Okay.
That is correct.
Okay.
So I think the preference would be not to allow the property owner to continue on with a claim that it no longer wishes to pursue.
Is there any additional authority other than Combs and the arguments about how these cases work in practicality that would provide an underpinning for this court to hold that Rule 41 does in fact apply to the landowner in a condemnation case?
There are unpublished opinions in the Court of Appeals that do say that it is a vehicle for allowing a property owner to end litigation in a condemnation action. Otherwise, I'm not aware of anything.
Okay, thank you.
Following up on your theory that Rule 41 does apply because the property owner is in the position of a plaintiff here, what's your response to the city's argument that in effect their motion to amend was like a counterclaim? They were counterclaiming for the amount back that they say, in light of the Court of Appeals' first appeal, they're entitled to at this stage. And that in those circumstances where there's a counterclaim pending, the plaintiff doesn't have the automatic right to voluntarily dismiss.
Well, in a situation, in the instant case, the city's, by filing a motion to amend, number one, it was filed under Rule 15A, versus filed under 136-103. But the motion to amend in and of itself wouldn't have survived a voluntary dismissal. Am I answering? Could you repeat?
Well, I think what I'm trying to understand is everything's flipped, right?
Yes. Yeah.
And so if Rule 41 applies because you're like the property owner is like
Right.
a plaintiff,
Okay.
why isn't the city's saying, no, we think the value is less? Why isn't that like a counterclaim to get back the amount of the deposit that they originally set?
Well, and the city, it was not, the motion, simply having a motion to amend does not in itself give affirmative rights or relief. It is the city cites McCarley as support for its position that the mere filing of a motion to amend gives it affirmative relief. But what McCarley says is that in that particular instance, the defendant actually had a independent claim that went beyond that he could have filed. It was McCarley was a divorce action. Mr. McCarley did have an independent claim he could have filed for divorce if the wife had not taken if the dismissal had not been denied or dismissed. She took a voluntary dismissal, and basically they agreed with everything. They were both in the same, and they totally agreed to the same conclusion, and it was more of an economy of justice that Mr. McCarley could pursue a claim on his own. In this case, the city could not have pursued a claim after we take a voluntary dismissal. They could not have pursued an independent claim to claw some of the money back.
But isn't the Court of Appeals decision in the first appeal what gives them the right or the basis to assert that just compensation is less than what they originally estimated? And related to that, I mean, what is the whole point of the first appeal? If they were to take that appeal, but at any point you can voluntarily dismiss and take the entire deposit?
Again, it goes back to the first appeal. If the property owner were to take the case to trial, it's the property owner's election to do that. That it could not present evidence of or damages related to loss of visibility. But again, it is the property owner's right to trial, and the motion to amend was city does not have the right to trial in a condemnation action. It has what it wants. It got what it wanted on the day of taking.
Does the city not have an interest in paying more than just compensation for obtaining a tract of property involuntarily?
Well, it's the property owner that gets to decide what is just compensation.
Backing up and taking a more, one of the problems with this case is that the statutes and the rules don't perfectly fit here. And
Correct.
so we've got to try to wrestle with the case based on whatever we can think of. In essence, it seems to me that admittedly, the city has an interest in taking property and paying no more than just compensation for it. Your client has an interest in making sure that you get just compensation, that those are the two interests. Why is the city's interest in not paying more than just compensation entitled to some consideration in this process?
Well, number one, it's the property owner that gets to decide what is just compensation until that time where it hands it off to a jury.
If you have a determination of just compensation, that's done by a jury, isn't it?
Well, it is up to the property owner.
In theory, neither party gets the right to unilaterally determine what just compensation is. Both of you have a chance to put in a typical case, both of you have a chance to put your evidence up and have a finder of fact, typically a jury, decide what the just compensation amount is, right?
Well, the property owner should have the right to be able to accept the deposit as just compensation right up until they hand that off to a jury.
Even if circumstances that affect the calculation of that just compensation change in the interim.
That is correct. There's always risk when you you file a condemnation action and instantly take title to the property.
There's risk everywhere. Assuming the city's position is correct, it took the risk that it made a mistake as to what the just compensation amount used to determine deposit was. You could have taken the deposit at that point, and I don't think Mr. Meeker contends if you had done that, he would have had the right to come back and try to get some of it back from you. There may be countervailing risk both ways, aren't there?
Well, but if the property owner, I think what the city is saying is that once you file your answer, the gloves come off, and they may withdraw that deposit. Again, they already have. This is not a voluntary purchase and sale negotiation. They already.
I think that's probably one of the few things we could all agree on.
Let me follow up in a more open-ended way. So much seems to be automatic here in terms of looking at how your position is. Once the governmental entity files the complaint, title automatically goes to it. That's automatic. You say, therefore, that there's an automatic entitlement to the deposit to withdraw it, and there's nothing that can be done to contest that.
Correct.
Then there can also be a voluntary dismissal by someone in your client's position, and that's automatic. With all this that's automatically done without a court needing to be involved at this stage, where would the aspect of the determination of just compensation come in, or does everybody just retreat to their respective corners, to use that colloquialism, and nothing else can be done because all of this has been so automated that there's no room for anything else?
Well, I do have to say that there is no mechanism in the statutes for ending the case, so yes, it would require the judge's discretion as far as requesting or approving a voluntary dismissal to some degree. But I do think, in a sense, it is what those condemnation statutes are all about. They are there to protect the property owner, and it is rather automated. And if the property owner does not decide to pursue a claim for additional compensation, then the case is over. They can simply accept, under 136-107, they can simply accept the deposit made as just compensation, and the court enters final judgment.
So to follow that to its logical conclusion, if there is a good faith deposit that's made by the governmental entity, and later on it is determined that there is some intervening factor, such as here, the Court of Appeals opinion, that the visibility was not impaired so as to be just compensation, then the governmental entity is just out of luck because of the fact that the landowner seized upon the opportunity to automatically withdraw the deposit, close the window on the case through voluntary dismissal, and that's it.
Yes, Your Honor. Sometimes there's this, between the property owner and the government, the property owner owning its property, going on about its day, and the city with the the ability to condemn, there has to be a limit. There has to be some sort of check and balance on the sovereign's authority. And that is why 136.103 specifically says they can amend their complaint and declaration taking, they can increase the deposit, but it doesn't say anything about allowing them to decrease the deposit. Between the two, it has to be, the city has to be the one that shoulders the burden when something goes wrong.
Before the time's gone, I have a quick question. Under these circumstances, if we apply Rule 41, you take the amount of the deposit, the case is over, and something happens after that within a year to really, really increase the value of the property, are you contending that you would have a right to reopen the claim under Rule 41A?
No, we would not. No, once a property owner takes voluntary dismissal, the case is over. It does not have the...
But the rule provides that you could.
Well,
So we're supposed to apply part of the rule, but not all the rule?
Well, I think the rule should be that in a condemnation action, when a property owner takes a voluntary dismissal, that does, just like the court in Coombs said, that acts to be an acknowledgement that the deposit is just compensation, and they do not have the right to bring back their claim a year later. So you're correct. Condemnation is forcible taking of private property. It's not a negotiation. These condemnation statutes are all that stands between us and the people, or between us and a government that thinks this is a voluntary transaction. The Court of Appeals got it right when it concluded that a property owner has the ability to end litigation in a condemnation case by taking a voluntary dismissal, and in holding that the city cannot amend its complaint to reduce its deposit, demand jury trial, or return any overage. On behalf of University Financial, the landowners in this courtroom and across the state, we respectfully ask this court to preserve the protections afforded by the statutes and affirm the Court of Appeals holding.
Thank you. Mr. Meeker, rebuttal.
Thank you. If I can make just two brief points. First, on Rule 41, the terms of it do not apply to a defendant. It talks about a plaintiff. Secondly, though, it's really a different situation. When a plaintiff takes a dismissal, that plaintiff goes home with nothing other than the right to refile, a right to redo. Here, if this defendant is allowed to take a dismissal, it's not just starting over and determining just compensation. It's winning that and getting the $570,000 compensation, including monies to which it shouldn't be entitled, the offside impacts. So this rule, it's different for a defendant here. It's not the same situation. There are some similarities, but it's fundamentally different in that the defendant would end up with $570,000. Not a doer like a plaintiff would actually prevail in getting compensation to which it's not entitled. And I think that's another point there, is that the Court of Appeals ruled on what they're entitled to. This court did not take the case on discretionary review the first time around, and the defendant shouldn't be allowed to, in effect, overrule the Court of Appeals and get that compensation anyway. The final point I wanted to make is just that since the Chapter 136 and the Rules of Civil Procedure do not have a procedure for this, the trial judge did have discretion, as one of the questions was, to rule on what was the fair thing, what carried out the purposes of Chapter 136, which is to achieve just compensation. And we feel the trial judge was correct and did not abuse his discretion. Thank you so much.
Thank you. Again, we appreciate the opportunity to hold oral arguments in historic Randolph County. We appreciate the lawyers' willingness to travel to be a part of this historical argument. And we are so thankful for everybody who has been so gracious in hosting us here today. Madam Clerk.
All rise. Oh yes, oh yes, oh yes. The Supreme Court of North Carolina will be in recess until 9:30 tomorrow morning in Winston-Salem. God save the state and this honorable court.